All right. Whoop. Almost all right. Okay. Let's get started. It's Tuesday the 14th, day after Falcons' big win over the Bills on national TV. Saw someone came in with, he's got his Falcons slanket on. Were you at the game last night? No? Okay, me neither. So we've got a plain arraignment calendar this morning and then probation revocation this afternoon. Position one on our calendar this morning is Willie Turner. Ms. Rios, is that your case or?
Ms. Wood.
Ms. Wood, okay. I think I could hear her voice. All right, well, we'll find out from her what's going on. How about Mr. Godfrey? Oh, Mr. Godfrey's got 3 cases in custody. And how are you dividing those up? Are they all Ms. Woods? Because
Yep.
well, isn't that nice? Okay.
Morning.
Good morning. Good morning, Ms. Wood. How are you doing today?
I'm well.
I'm also well. So we just started calling the calendar. I'm going to rewind because the first few cases were yours. So Willie Turner is here. Great. And then Mr. Godfrey.
There's just an arraignment on all 3 of us.
Okay. Eugene Cousin. Mr. Cousin, if we had contact with him.
Request the bench warrant for Judge Host.
All right, I'm pulling up his case. Okay. Should Mr. Cousin surface, we can walk him in and work through that. The incident was 3 years ago, but he did have appearances about a year and a half ago in court, so it's a little fresher than it sounds. Oh, thank you. Oh, we have this bonus calendar. All right, thank you. So bench warrant for Mr. Cousin. Tashan Johnson. He's right there. Okay.
I just need to, I just did start talking to him when you came out, so I just need to go over the things with him and the workshop.
Okay. Then we'll chat when you're done talking with him. Jeffrey Keene. It's our Falcons fan. All right.
We've talked before court and I believe I filed a wager.
All right. Well, let's check and we can get Mr. Keene out of here. You did. Mr. Keene, are you still living on Perkerson Road?
237
Oh, we got 2379. You moved one house away? How come? That just seems like a big production to move like one house down the street.
You know, it looks better, you know.
Good. Well, that's a good move then. All right. So 2376. Deputy Gordon is going to locate our change of address form, and you and Ms. Rios should fill that out. And then well, let me see. That's interesting. There may have been one filed and it didn't stick, but we'll try again. No, the one that was, oh yeah, they didn't switch it. So you did file one. Thank you for doing that in September. But let's do one again to get the address changed. Or someone did it for you if you didn't. You did it. Good. That was the right thing to do. Okay.
On this incident, I wasn't read my record right.
Okay, so don't- Yeah. There may have been a lot of things that didn't happen the right way. That's where Ms. Rios is going to help you out. And it looks like your case was dismissed at one point, but that's probably because the officer didn't show up. I'm just looking for your bond, which may be gone because your case was dismissed. So if you don't mind writing that all over again, the 2376. Okay. Oh, all right. You're just supposed to not fight with the police while you're on bond. So let's do that, okay? All right. Okay. This seems pretty resolvable, Ms. Rios, just looking at the charge, but you're going to want to talk with Mr. Keene, get discovery from Ms. Davis. So Mr. Keene, once you filled that out and it's legible, in other words, he can read it, then do you need Mr. Keene to stick around or he can go?
I think he has more questions, so.
Oh, you have more questions? Oh, for you?
Yes.
Okay. Yeah, then you should stick around. We'll get through this calendar in a minute, then you can talk with Ms. Rios. Sure. How about Detravius Stringer?
No, she's mine, he was excused. Oh, we were this.
All right. Harvey Mitchell.
Good.
Hello, Mr. Mitchell. How are you doing? Okay.
Judge, he's mine. This was yesterday. I filed a waiver and I'm gonna just make sure he has my contact information before he leaves.
All right. Mr. Mitchell, I got a couple of questions for you. Let's here. Mr. Mitchell, I've got an address on Lincoln Street, but also one on Mackenzie Road.
341.
341 Lincoln Street's the right one? Good, okay. And your bond order says you need to stay away from a Tracy Walker. Do you know who that is? No? Okay. Well, that makes it easier to stay away from the person. Do you have a driver's license? How'd you get here today? Okay. From Lincoln Street? Where's Lincoln Street? Oh, okay. All right. Then we're good to go. If Ms. Wood says you're good to go, I appreciate you being here. You'll get notice when to be here next. Perez Mann.
Judge, I think I have an excuse as well.
Okay.
Yes. And that's gonna be my case, Your Honor.
All right. So you already did a waiver and I guess you got bond for all this. Okay. And that's a Ms. Willingham case. Clarence Pitts.
Would be mine, but I have not had any contact with him. Well, also, it looks in the system, well, he would be my baseball numbers, but I don't know if he ever was with our office. I didn't see an entry from anyone in our office.
Okay.
That's also gonna be mine, Your Honor, and the state that we're supposed to be subject to that.
Okay. Attorney back, he had a public defender at least at first appearance. And they verified his address at his first appearance, which was just about a year ago. So I'm gonna say he's sort of around-ish. So we'll do bench warrant for Mr. Pitts. All right, so Mr. Turner's a plea, Mr. Godfrey will be an arraignment. No, Mr. Cousin, unless he walks in a few minutes. Mr. Johnson, you're going to talk to more. I think that's it. Do we want to, for this first part of the calendar, do we want to bring Mr. Godfrey out for the arraignment? Okay, please. Then I'll call this add-on calendar and we'll see what we're doing there. Because we do have a gentleman who seems to just be standing out on the street. We could take care of him.
I believe he's a blade.
Hmm?
I believe he's a blade.
Oh, okay.
Number seven. Number seven.
Number 7, what?
Were they?
Keen.
Yes.
Yes, no, was Mr. Keen here? Yes, he was here. Yeah, the only bench warrants are 5 and 11. Yes, well, 10 wasn't here, but it's not a bench warrant. Hey, Mr. Godfrey, if you just come to the podium here. Good morning. So I'm Judge McBurney, and you have 3 cases that have been assigned to me. One charges you with aggravated assault. One charges you with escape, some other charges as well. Escape, and then the last one is a rape case. That would be the most serious of the charges, 3 different cases. And today is your first appearance in front of me. It's what we call the arraignment. That's an opportunity for you, through your lawyer, to either enter a plea of not guilty, which then starts the process of getting discovery produced and all that kind of stuff, or entering a plea of guilty, which doesn't usually happen right out of the gates, especially with some of these charges. I can formally arraign you, which means I read the specifics of all 3 indictments into the record, and you then say on the record whatever your plea is, guilty or not guilty. But your lawyer, Ms. Wood, can waive arraignment on your behalf, which just means I don't read into the record what each of the charges is. That enters that plea of not guilty, and then we start the process of making sure you and your lawyer are getting all the information about each of the 3 cases. Ms. Wood, does Mr. Godfrey want to waive arraignment?
Yes, Judge, we'll waive formal arraignment. I filed waivers yesterday, so we'll enter pleas of not guilty and just move forward to the next court date.
Okay. Mr. Godfrey, I will see you next once Ms. Wood files any motions on your behalf. You and she will talk about that after she gets discovery. That'll give her a chance to see, well, what did the police do in this case or fail to do? Are there things that she ought to try to exclude from any trial of any of these 3 cases? She'll talk with you about that, and if she thinks it makes sense to file motions, she'll do that. If there are not motions filed in the case, then I'll see you soon for what we call final plea, which is an opportunity for you to resolve the cases short of trial if you think you should, and the offer you're getting is something that you think is reasonable. If not, then my goal is to get you into court for a trial of one of the cases, and then we'll go from there. Ms. Wood, anything else on behalf of Mr. Godfrey?
No, Judge, thank you.
All right, Mr. Godfrey, any questions for me? Okay, all right, we'll see you soon.
Thank you, Judge.
Yes.
So we have an add-on calendar. Position 1 is Darshir Brewington. It says that's on for a plea.
Yes, good morning.
Hey.
What could Jack for Mr. Brunson? We received some information yesterday from the state that I did convey to Mr. Brunson. At this time, he needs an opportunity to speak with his family, so I asked that we be added to a final plea calendar, and I have completed the waiver of arraignment for the court.
Okay, so is he here?
He's in custody.
Oh, he's in custody.
Yes.
Okay, all right. Give me 1 second here. So he hadn't ever been, I guess there was a bench warrant for him back in the day. He got picked up on that bench warrant and is now here. And our calendar last week, which collided with the trial calendar, was to figure out what are we doing about the bench warrant. But maybe you were on leave then?
I was on leave,
Okay,
yes.
great. Well, welcome back.
Thank you.
And then I guess something must have made you think this was resolvable because it got put on for a plea.
Everything about this made me believe it was for.
Okay, but now it's not?
He just needs an opportunity. He didn't have an opportunity to come speak to his family last night
Yep.
at the jail, so he
Okay.
just needs an opportunity to do that. So
Okay,
I do believe we should resolve this short of a trial.
okay. Does it make sense? You said to put it on a final plea calendar. We could do that. What will happen with this waiver of arraignment is a scheduling order, and that final plea is a little ways down the road. And if he is close to working this out and just needs a little family time, you may not want to wait the 3-4 months until that final plea date. Should we put it on a date sooner, or do you want to let Ms. Nelson know? We can go ahead and do our scheduling order, and then as soon as you've got a sense that it's worked out, you can just let Ms. Nelson know, and we'll put it on the next available
I
calendar.
can do that and just let Ms. Nelson know.
Okay, then what we'll do is get the scheduling order in place. That'll have its own set of deadlines. You can always accelerate things if the stars align, the family provides good counsel. Then we'll just bring Mr. Brewington here on a day that works for you and Ms. Davis, your case?
Yes, sir.
And Ms. Davis, so we'll handle it that way.
Sounds good.
Do I need to chat with Mr. Brewington at all, or is he good?
He's good.
Okay, well, thank you for managing that, and with this waiver, we are all set.
Thank you, Your Honor.
You bet.
May I be excused?
Yes, ma'am.
Okay.
Marcus Moment. Yes, and it's on for a plea?
That's the regretted judge.
Okay, both cases?
Okay.
All right, and then Mr. Perrin is online, also a plea. Ms. Rios is gone, but yes. You think that, Ms. Willingham, we think Mr. Perrin is a plea?
It is my yes.
Yeah, you can talk about, we have lawyers in here, so it's okay.
It is my understanding, that is a plea, Your Honor.
Okay, great, lots of pleas. Mr. Daniels is online, that's a plea, so we'll probably do that next. And then Mr. Willis, he's in the Department of Corrections.
Yes, Judge, and I ordered, I did a video request, however, they were closed yesterday.
Okay,
But I got an email back to them and they said they can do it this afternoon, but I'm waiting for the attorneys. to
All right.
confirm.
got it, because this is Hiles and Rhodes. All right, hopefully we can do it this afternoon, anytime. I'm happy to pause. This afternoon, briefly on that, it's one revocation and one evidentiary hearing. Mr. Nolly, is that still an evidentiary hearing?
No, Judge, this is not gonna be an evidentiary hearing, and I can explain to the court why.
Okay.
It should be.
We'll talk about that this afternoon. That just helps me understand. We've got more time this afternoon if we have to put a couple of these pleas in the afternoon. Okay, let's do Mr. Daniels. Hey, Mr. Daniels, can you turn your microphone on? There he is. All right. Good morning, Ms. Rivers. Are you able to hear us?
Yes, I'm here.
Yes, I
Yes, I'm here.
Great.
Mm.
Okay. Mr. Daniels, where are you right now? Mr. Daniels, are you in Atlanta? Are you in Dallas? We can't hear you right now.
I'm right over in the Polar Rock area.
Okay. Are you able to take a seat for a minute?
Can you hear me now?
Yeah. Are you able to take a seat for a minute? Like, is there a bench nearby?
Hold on, it's not their phone.
Mr. Daniels, can you hear me? So how far are you from the courthouse, Mr. Daniels? Do you have a way to text him?
Yes.
Can you hear us now, Mr. Daniels?
Yes, I can hear you now. I'm sorry.
That's okay. Are you in a position where you could like take a seat on a bench or something?
Yes, I can.
All right. Why don't you do that? Because then we'll know if you're in a sitting still and we can hear you, that shouldn't change while you're sitting there.
Okay.
All right. There we go. So you can hear me.
Yes, I can.
Great. All right. Well, we're going to get started. Let me add one more camera here so you can see your lawyer. There she is. All right. This is 25 SC 003 State versus Glenn Daniels. Mr. Daniels is appearing virtually. Mr. Daniels, are you comfortable appearing from where you are instead of being here in court?
Yes, I am.
Good. And are you all right with the fact that Ms. Wood, your lawyer, is here in court rather than right by your side?
Yes, I am.
If you need to speak with her privately, will you let me know? Because I can have her step outside and she can call you up on your phone so you can have a private conversation. Will you let me know that?
Yes, I will.
Okay. In a moment, Ms. Davis, who is on the screen, if you can see it on your phone, is going to swear you in. She's the prosecutor handling your case. She's going to ask you a bunch of questions. You need to answer all those questions, all right?
Mm-hmm.
Okay. And when you are answering, make sure it's a yes or a no or I don't know or 19 or whatever the answer is. And not mm-hmm. Okay?
All right.
All right. Ms. Davis.
Okay, I'm sorry about that.
Mr. Daniels, please raise your right hand. Do you swear or affirm the testimony that you will give in this matter before the court shall be the whole truth and nothing but the truth?
Yes.
You can put your hand down. Please state your true, correct, and legal name.
Glenn Kirk Daniels.
Are you at this time under the influence of any alcohol, drugs, or medication?
No, I'm not.
Is there any medication that you normally take that you have not taken today?
No, there isn't.
How old are you and how far have you gone in school?
I'm 42, the ninth grade.
What high school did you attend?
West Fulton and Davis County High School.
Are you able to read, write, and understand the English language?
Yes.
Are you a United States citizen?
Yes, I am.
Do you understand that you're charged with the following offense in 25 SC 003 simple battery family violence?
Yes.
And Judge, the state is moving to null process terroristic threats and acts.
Okay. So we're proceeding just with a misdemeanor. Okay.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your lawyer, Attorney Wood, about all the facts and circumstances known to you about the charges in this indictment, including any potential defenses?
Yes, I am.
Do you need more time to discuss this case with your attorney?
No, she ran over everything with me prior to my court date.
Are you satisfied with her services?
Yes, I am.
Attorney Wood, do you waive formal reading of the indictment and any and all defects therein for the purposes of this plea?
We do.
Mr. Daniels, do you remember being arrested on these charges?
Yes, I do.
Your Honor, the state's unaware of any outstanding warrants related to this matter. Attorney Wood, are you aware of any outstanding warrants related to these charges?
I'm not.
Mr. Daniels, has your attorney advised you the minimum and maximum sentence for the charge to which you are pleading to today?
Yeah.
And the maximum sentence is 12 months.
Yes.
Do you understand that today you're entering a negotiated
Yes.
plea of guilty, which means the state will make a recommendation to the court?
Yes.
Do you understand the court's not required to accept the state's recommended sentence?
Yeah.
Do you understand the court has the right to sentence you to the maximum possible sentence on this charge?
Yes, I do.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of that sentence?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including federal courts?
Yes.
Do you understand that if you're not do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following trial?
Yes.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would? And that is true regardless of any advice by your attorney or anyone else.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights? I'm going to go over about 9 of them and then ask you, do you understand? Okay.
Mm-hmm.
Okay. You're giving up the right to a
Mm-hmm.
trial
Yes.
by
Yes.
jury.
Yes. I'm sorry.
Okay. You're giving up the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand that?
Yes.
You understand you may have only a limited right to appeal this guilty plea conviction.
Yes.
Do you understand that you have only 12 months from today for the misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
How do you plead to the charges in indictment 25 SC 003003 to the count of simple battery family violence?
Guilty.
Has anyone forced you, threatened you, or promised? Thank you. Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
No.
So, Mr. Daniels, the question that Ms. Davis just asked is, are you working this case out today because you are entering a plea of guilty to this one count of simple battery that you supposedly punched this guy, it was about a year ago? I thought that's what we were doing, is that you were entering a plea of not
yes.
guilty. You don't have to, you can say not guilty and then we can have a trial. I just need to know your plan.
Oh, yeah, no, I'm sorry. Yes, yes, yes. No, 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 no. I was pleading guilty. I'm sorry.
That's okay.
I didn't hear
That's
what you were
okay.
saying correctly.
I got it. You're entering a plea of guilty to the misdemeanor. All right, you can keep going.
Is this guilty plea freely and voluntarily given with the
Yes.
full knowledge of the charges against you? I just need you to state your
Yes.
answer again. Yeah, okay, because we were talking at the same time. Your Honor, the state believes the evidence would show that on July 18, 2024, officers were dispatched.
Yes.
Now it's my part.
It's a delay.
Yeah, we got you. She's going to talk for a little bit now. Keep going. This is sort of like he's actually not at a bench here in Atlanta, but a bench maybe on Mars or Venus. I'm getting the signal. It's all good.
Your Honor, on July 18, 2024, officers were dispatched to a location. However, that location was not where the incident occurred. The incident actually occurred at 2428 Lakewood Avenue in Atlanta, Georgia. This is a physical fight that occurred between cousins. So the victim, Mr. Malcolm Del Rey Deal, and the defendant, Mr. Daniels, get into a physical altercation. At that property, officers met with the victim's mother, who advised that her son should be on the property, but not her nephew. However, the officers note that Mr. Daniels was living at that location. There was a disagreement. We're not sure why. The defendant alleges that the victim hit him with a chair, although officers did not observe any physical manifestations of him being hit with a chair. But the defendant did make physical contact with Mr. Del Rey Deal, who is the victim, and they did notice that he complained about jaw pain from being punched. This is a fight between cousins that appears that they continue to have fights, is my understanding. Our victim's advocate did speak with the victim, and now he's a defendant in another case with the defendant. So to resolve this family matter, we are amenable to just a misdemeanor to resolve this case. Mr. Daniels did about 121 days in custody. So our recommendation is 12 months to serve 4 months, which he's already done, balance on probation, for him to complete an anger management course, 40 hours community service, obtain his GED, or provide proof to probation. No contact with Mr. Malcolm Deal, and to stay away from the location where the incident occurred, which is 2428 Prior Road in Atlanta, unless he still lives there.
I thought you said it was Lakewood. So was the incident 2428 Lakewood or 2428 Prior?
2428 Lakewood.
All right.
Not Prior.
Okay. Got it. Thank you for that. Ms. Jackson, good morning. Criminal history information for Mr. Daniels, please.
Good morning, Your Honor. There are 28 cycles. The last arrest was May the 27th, 2025, with the City of Atlanta Police Department for theft by shoplifting and criminal trespassing. There is no disposition for that arrest. He does appear to be on probation in Fulton County. That case number is 22 SC 182830 for aggravated stalking. That disposition date was April the 17th, 2023. The term is for 9 years. He does have prior felony convictions, one in 2016 out of Fayette County for crossing state/county guard lines with weapons, intoxicants, and drugs without consent. It's one in 2013 out of Douglas County for possession of controlled substance with the intent to distribute. One in 2011 out of Henry County for theft by taking. One in 2009 out of Douglas County for possession of controlled substance. One in 2002 out of Douglas County for possession of controlled substance. There are misdemeanor convictions and sentences.
I don't need those. You've shared enough. I appreciate that.
Okay.
Oh, all right. Thank you so much. Ms. Wood, we've got this probation wrinkle here, but I'm happy to hear whatever you want to share.
Asking if we want to resolve that alongside.
Well, I'll hear from Ms. Simpson in just a minute. I don't know if you knew that was out there.
I'm happy to work through it.
Okay.
That's something we should do today.
Okay, can you bend your microphone down so Mr. Daniels can hear you? Okay. Why don't you tell me about Mr. Daniels and his case, and then we'll come back to probation.
Yes, sir. So Ms. Davis is correct. We served 1 days for this, July 19th, 2024 until November
Excuse me,
16th.
Ms. Wood, is your microphone on?
It's on. Can you hear me?
Yes.
Okay, so yes, Ms. Davis is correct. He served 121 days from July 19th, 2024 until November 16th, 2024. Judge is eager to get this behind him, so we just ask that you accept the state's recommendation.
Okay, and you're waiving any due process notice rights if we look at the probation situation now?
Correct.
Okay. Ms. Simpson, is Mr. Daniels in fact on active probation in that 22 SC case?
Judge, he currently has 6.5 years left. He's already been revoked on this case by Judge Dunaway, August 28th, 2024.
Oh, as a result of this arrest?
Yes.
Oh, then we're taken care of.
However, the misdemeanor case that Ms. Jackson mentioned put him back in violation. So there is a warrant pending.
Okay, as in it has not been signed yet? Okay, we'll let that work its way through the process, but it sounds like we don't have a probation issue with this plea because there's already been a revocation. Okay, Mr. Daniels, anything you want to add that you think I should hear? I couldn't hear you. I saw your mouth move, but I couldn't hear you.
No.
Okay, I have a couple questions for you.
No,
One of the conditions of your sentence is that you have no contact with your cousin, Malcolm Dill.
No, there isn't.
Okay, are you going to be able to stay away from Malcolm Dill, or do you guys live in the same place?
Mm-hmm. Yes.
Okay, and what about that
No,
address?
we don't live together. No, I can stay away from it.
Okay, this is interesting. The address on Lakewood Drive, do you still stay there?
No, I do not. No.
Okay. Mr. Daniels, I find there's a factual basis for your plea to simple battery. I'll accept your plea. Find that your plea is knowing and voluntary. I will follow the joint recommendation here and sentence you to 12 months to serve 4 months with the balance on probation. You'll get credit for the 121 days you served. Special conditions of your probation are: 1, complete an anger management course, and probation will help you find that. 2, you will need to complete 40 hours of community service, and you'll need to do that in the first 6 months of your probation. If you haven't, I want probation to come find me so that we can talk about why you didn't do that in the first 6 months of your probation. You'll need to have no contact with your cousin, Mr. Dill, and you'll need to stay away from 2428 Lakewood Avenue. Ms. Wood, can someone in my office sign the indictment for you? Ms. Davis, can we sign for you?
Yes, Your Honor.
And Mr. Daniels, can we sign your name on the indictment indicating your plea to the misdemeanor?
Yes.
It's like the storm is getting further and further away as you see the lightning and then the thunder takes even longer. All right, Mr. Daniels, I'm gonna let you go. Ms. Wood will be in touch with you about misdemeanor probation. Appreciate you taking time to do this, and we'll move on to the next case. Just a second, let me say goodbye. There we go, he went away. Okay, that was interesting. Yes, let's go back to our plea and arraignment calendar and this is Tayshaun Johnson. So you're waiving arraignment? You've got good contact information for him? All right, yes, you're good to go. You too. All right, we could do Mr. Perrin, he's online. I don't think there's anyone else online right now, and then we'll just be dealing with folks who are in custody. Does that work? Great, okay. Mr. Perrin, can you turn your microphone on, please? All right, I'm really hoping your connection works better than Mr. Daniels. Can you say good morning, Judge?
Good morning, Your Honor.
Ooh, that's great. You sound like you are right next door. This will go much more smoothly. All right. This is a Willingham production?
Yes.
All right. Okay. Well, let's get on the record. This is 25 SC 002-766 State versus John Perrin. Ms. Willingham is here for the state. We've got Ms. Rios for Mr. Perrin, and Mr. Perrin is appearing virtually. Mr. Perrin, tell me where you are right now.
I'm in Martinez, Georgia.
Where's that?
It's about 8 miles away from Augusta.
Oh, all right. Well, Mr. Perrin, you are welcome to appear from there. I need you to tell me, though, on the record that you're okay being there rather than in court. You've got a right to be in court, but you can waive that right. Are you waiving it?
Yes.
Okay. You also have a right to have Ms. Rios sit next to you in Martinez, Georgia, but she's here in court. Are you all right with the fact that she's here and you're not?
Yes.
All right. If you want to speak with her privately, just let me know and she can step out and give you a call. Will you do that?
Yes.
All right. And if during our conversation you cannot hear what's going on, you've got a question about what's going on, will you wave your hands and let me know?
I sure will.
Okay. Then Ms. Willingham's going to put you under oath, ask you a bunch of questions, and we'll take it from there.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. Please state your true, correct, and legal name.
John Edward Perrin III.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
How old are you and how far have you gone in school?
I'm 55 and I've had 2 years of technical school.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have a right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes.
Have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need more time to discuss the case with your attorney?
No.
Are you satisfied with her services?
Yes.
Counsel, are you satisfied your client has a full understanding of this proceeding?
Yes.
Have you reviewed the indictment in this case?
Yes.
Do you waive formal reading of the indictment? Has your client been arrested on these charges? The state is unaware of any outstanding warrants related to these charges. Do you or your client know of any outstanding warrants related to these charges? Mr. Perrin, do you
Yes.
understand you are entering a guilty plea to the following offenses? Count 1 of this indictment, aggravated assault, will be reduced to battery family violence, misdemeanor, which has a minimum of 1 day and a maximum of 12 months. And count 2, battery family violence, has a minimum of 1 day and a maximum of 12 months.
Yes.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 24 months probation, and the special conditions will be that you have to be evaluated for both substance abuse and mental health, follow any recommendations from those evaluations, complete family violence intervention program, and have no violent contact with the victim. Is this what was explained to you by your attorney?
Yes.
Are you aware that the court does not have to accept that recommendation, and the court can sentence you up to the maximum sentence on each charge and can run those sentences consecutively or one after the other?
Yes.
Do you understand that if you do not accept the court sentence, you may withdraw your plea?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes.
Do you understand, because these are family violence convictions, if you are found in possession of a firearm, you could be charged on the federal level?
Yes.
Do you understand? Are you currently on probation or parole anywhere for anything?
No.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the reduced charge of battery family violence in indictment 25 SC 00 2766?
Guilty under Alfred.
And how do you plead to count two, the original charge of battery family violence in that same indictment?
Guilty under Alfred.
Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes.
Is this Alfred plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you have 30 days in which to appeal your conviction based on your plea today?
Yes.
Do you understand that you have only 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Your Honor, if this case were to proceed to trial, the state would expect to show that on December 29, 2024, Officer Walker with Atlanta Police Department responded to 63 Truman Avenue in Atlanta, Georgia, Fulton County, regarding a physical altercation. The officer met with the victim, Miss Demetrius Perrin, the wife of the defendant, John Perrin. The victim reported that the defendant was drinking all day and got upset when she did not want to have intercourse with him. The defendant hit the victim on her head with a closed fist. A few hours later, the defendant punched her and they began to tussle on the ground. The defendant got on top of the victim and choked her. The victim had visible marks on her neck and shoulders. And Your Honor, when I spoke with the victim, initially I sent her a text message where I called her and she did not answer, but I saw that it's best to get in touch with her by text. And I checked with her to see if she still was primarily interested in the defendant getting mental health services, because that's what she had previously expressed to our office. And she stated that she did, and that was all she would like to see happen in this case.
And as far as she communicated to you, they're still married, they still cohabitate?
Yes, Your Honor, that is my understanding, but there was also a note that stated she was out of town. There wasn't clarification as to whether that's like a permanent out of town or a temporary, but she did specifically say that they are still in communication, which is why we asked for no violent contact.
Okay.
I'm sorry, I'll go through the. Yeah, really quick.
Mr. Perrin, let me get a little more information, and then you and I will talk. Ms. Jackson, do you have any criminal history information on Mr. Perrin?
Yes, Your Honor. There are 7 cycles. The last arrest was July the 31st, 2017, with the City of Atlanta Police Department for driving while license suspended or revoked. There was no disposition for that arrest. He has 1 misdemeanor conviction. That was in 2010 out of South Carolina for possession of marijuana less than an ounce in an open container. Nothing in addition, Your Honor.
Thank you. Ms. Rios?
Mr. Perrin is 55 years old. He's currently on disability. He had 2 strokes, and he's also legally blind. So I'm asking for his fees to be waived. Right now, he's living in a town near Augusta. I can't remember the name. He's living with
Martinez. Should we say Martinez, where I grew up? Because I grew up near a town called Martinez. Like, wait, what? Martinez. But that's sort of like Cairo. How do people say? Cairo. They don't say it the same way as in Egypt, or Houston. Anyway, Martinez. I saw it on the map. It is near Augusta.
He's living with his mother there for the time being. So he's having a lot of doctor's appointments, just trying to focus on his health. And I believe this is a good resolution to this case he's doing in Albert, because saying it's not quite how it happened and how the police were saying, especially when they're saying that he was drunk, because he has deficits from the stroke that might have the officers believe he's drunk.
Okay.
So he was very adamant about that.
So the stroke predates this incident of the 29th of December of last year.
Yes, sir.
Okay.
So we just asked that you accept the plea as negotiated.
Okay. What is your understanding of where Demetrius Perrin is in Mr. Perrin's life now? Is she staying at his mom's house as well?
I believe so. Maybe Mr. Perrin, because my understanding is they weren't living together anymore.
Okay, well, I'll ask him. I just was seeing if you had an update. All right, so staying with mom, she's helping support him, and he's on disability. Mr. Perrin, do you have questions for me?
No, Your Honor.
Okay. How long have you been staying with your mother in Martinez?
Since I was released from custody.
Okay, and that would have been, I guess, in early February?
Yes, Your Honor.
Okay, and your stroke or strokes all happened before this situation?
Yes, Your Honor.
And you're not taking any medication for it?
Yes, I do take medication.
Okay, well, that was one of the first questions that Ms. Willingham asked you. What do you take medication for?
Well, I'm a diabetic, and I have pancreatitis. I had empyema, so I had surgery on my lungs.
Okay, well, rather than, I didn't mean for you to have to share with us all your medical woes, but that's sort of how I asked it. You do take medication for a number of things. Does any of that medication make you woozy or drowsy or knock you out?
No, Your Honor.
Okay, you've understood what we've been discussing?
Yes, Your Honor.
All right, and what is the answer? Demetrius Perrin, where is she these days?
She's still living on Truman.
Okay, well, you guys, whatever happened on the 29th of December, she's still at that place?
Yes, Your Honor.
Okay, do you guys talk or write notes to each other, or do you stay in touch?
Yes, I have to. That's my wife. I still have to send her money. And
okay, I think that's good as long as that's a healthy relationship. So you guys are in touch with each other. It's just that you're in Martinez and she's in Atlanta.
Until they take this ankle monitor off.
Oh, you got ankle monitor on. So that'll come off after you enter a plea. Does that mean you're moving back to Truman Avenue?
Well, after I complete my whatever my sentence is.
Okay, well, your sentence does not require you to stay away from Truman Avenue. It will get your ankle monitor off you, although I'll tell you, you're going to need to come back to Atlanta to get the ankle monitor off. It doesn't just magically pop off once I sign this piece of paper. You'll need to meet with folks from Second Chance, and I don't believe they're in Martinez.
Well, that's just a condition that me and my wife worked out. We just decided it'll be best that you
work through what you need to work through.
Right, because we've been together 32 years, so I'm just not gonna walk away like that. But I'm gonna do whatever I have to make sure that she feels safe, that nothing like this ever happens again.
Okay, well, that family violence intervention program is going to be the big one then. All right, well, Mr. Perrin, if you don't have any other questions, I don't have any other questions. You good to go forward?
Yes, sir.
I find there's a factual basis for your plea to 2 counts of family violence battery. I appreciate it's an offered plea that you're saying, it didn't happen quite like the police said, but you are acknowledging that if it went to trial, it could result in a conviction for you on family violence battery, especially if an officer testified that there were marks around your wife's neck and shoulders. That would be hard to explain. I also find that your plea is knowing and voluntary, meaning you've understood what we talked about. No one forced you into this plea. Ms. Rios, can someone in my office sign the indictment for you? Ms. Willingham?
Yes, Your Honor.
And Mr. Perrin, can we sign your name to the indictment indicating your offered plea to the 2 misdemeanors?
Certainly.
Great, we'll do that. I will, for the most part, follow the recommendation. Your sentence on count 1 is going to be 12 months to serve 1 month. with the balance probated, but you'll get credit for the time you served. Your sentence for count 2 is 12 months probated consecutive to count 1. So it's a total of 24 months to serve 1 month with 23 on probation. Special condition number 1 of your probation is no violent contact with Demetrius' parent. Number 2 is that you complete the Family Violence Intervention Program, which is a series of classes, and I am requiring that you enroll in that within the first 3 months of your probation. Not that you finish it, but that you start it within the first 3 months of probation. You'll need to submit to a mental health evaluation, and if that medical professional recommends any treatment, counseling, anything like that, you'll need to follow that treatment. And similarly with a drug and alcohol abuse evaluation, although the focus there is not, hey, you're taking medicine to treat all your medical conditions, it'd just be making sure you don't drink too much on the side. And if any treatment is recommended, that's part of your sentence. And I will waive your probation supervision fees given that you support yourself and your wife through the disability that you receive. Does your mom work? How does she take care of things in Martinez?
Yeah, she works. She's a hairdresser.
Okay. And does your wife work?
She's a cosmetologist as well.
Okay. So they're both working some. All right. Anything else, Ms. Rios? Ms. Willingham?
No, Your Honor.
All right, that's it, Mr. Parent. If you don't have any questions, Ms. Rios is going to be in touch with you about how misdemeanor probation works, okay?
Okay.
All right, take care of yourself.
You enjoy your day as well.
All right. That takes care of Mr. Perrin. And so now we can work through, in whatever order you guys want to work through the remaining pleas. We do have someone here, ma'am. You're here for what case? Why don't we do Mr. Turner first? Both of you getting out of here? Yes, before you go, I don't think we have scheduled a little meeting about the trial calendar, but we're calling the trial calendar Thursday afternoon. And so do you have any cases, Ms. Rios, on that? They mostly say Wood. Okay, well then you definitely can go until Ms. Wood palms one off on you. They mostly actually say private attorney. And I suspect we're going to go out with Mr. Gentle, which I don't know if Ms. Clark is keeping it, but I let Ms. Williams know that's probably to go. Do you have anything on the trial calendar?
No, Judge, the one case I had was.
You have Hairston?
Yeah.
Yeah, and I appreciate you. It was the right thing to say, look, the family needs to make plans. We need to try that case and you need to get Mr. Banks.
Agreed, we're gonna talk again.
Oh, I don't mean you need to get him to resolve it. He should, I mean,
No, we're
but
gonna
he needs
talk
to get
again.
ready.
That's what I've expressed to him, so I
Yeah.
thought the November calendar came out, was hoping it was gonna get bigger, but.
No, we figured we'd give him one bump, but it may make it onto the December Emerson calendar, because our December is kind of full, but it might be on both. Some of us put it on both, not because you have to be in two places, but hey, if we don't get reached in Emerson, then you'll be here.
I will give the family a heads up, thank you so much, I just didn't want, and this is actually the victim's birthday week, so I didn't want them to be in limbo.
Yeah.
With that already, with them wanting to celebrate your birthday.
Yep, okay, you bet.
Okay, I will.
All right, let's do that. And do podium. There we go. It's great seeing you, Ms. Rios. Only say it if you mean it. Hey, I do want credit. Oh, see, he always takes it away. I filled the candy bowls today.
Thank you.
I did. That wasn't, it's usually Ms. Wood, I know, but this was, I was at Costco, 2 weekends ago, and they sell these Halloween candy bags. So I got stuff so it's fresh, first of all. It's not, because it hasn't been Halloween yet, so it's not like it's my kids' old Halloween candy. It's virgin candy right out of the bag. And there's so much more left. So I know Gordon will take it off that table, but you guys should feel free to help yourself.
Thank you.
Okay, good. All right. Credit. All right, Mr. Turner, how are you?
Good, sir.
I'm Judge McBurney, and you are ready to enter a plea in your case, is my understanding.
Yeah.
Okay. Ms. Davis is going to put you under oath in just a moment, ask you a bunch of questions about your case. You'll need to answer those truthfully. Ms. Wood will share a little bit about your situation, and we'll go from there. Your case is 23 SC 189044. Ms. Davis.
Thank you, Judge. Ms. Wood, is this a non-negotiated or negotiated plea? I can't remember.
Negotiate.
Mr. Turner, please raise your right hand. Do you swear or affirm the testimony that you will give in this matter before the court shall be the whole truth and nothing but the truth?
Yes.
You can put your hand down. Please state your true, correct, and legal name for the record.
Willie Turner.
I need you to, not jingle the chains. Thank you.
Let's go one more time. We have a court reporter taking this down.
Willie Turner.
How do you spell Willie?
Willie.
Okay. Are you at this time under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not taken today?
No, ma'am.
How old are you and how far have you gone in school?
44. 9th grade.
What high school did you attend?
McNair. And Columbia.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Are you a United States citizen?
Yes.
Do you understand that you're charged with the following offenses in indictment 23 SC 189044, theft by taking and battery?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you will receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer, Attorney Wood, about all the facts and circumstances known to you regarding this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No.
Are you satisfied with her services?
Yes, ma'am.
Attorney Wood, do you waive formal reading of this indictment and any and all defects therein for the purposes of this plea?
We do.
Mr. Turner, do you remember being arrested on these charges?
Yes.
Your Honor, the state's unaware of any outstanding warrants related to this matter. Attorney Wood, do you know of any outstanding warrants related to these charges?
I do not.
Mr. Turner, has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading to today?
Yes, ma'am.
For theft by taking, it's 1 to 10 years, and for battery, it's 12 months.
Right.
Do you understand that today you're entering a negotiated plea of guilty, which means the state will make a recommendation to the court?
Yes, ma'am.
Do you understand the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that there are multiple charges to which you are pleading guilty today, and the court has the right to run those sentences consecutively or one after the other?
Yes, ma'am. Sure.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of that sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including federal courts?
Yes, ma'am.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would? And that is true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
You understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you would be guilty of a felony, which may carry a sentence from 1 to 15 years in prison.
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, ma'am.
For example, your guilty plea may affect the right to vote, to hold public office, to serve in a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
You understand that by pleading guilty, you're giving up the following rights, and I'm going to go over 9 and then ask you, do you understand?
Yes, ma'am.
The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you have only 4 years from today for the felony charge and 12 months from today for the misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
How do you plead to the charges in indictment 23 SC 18944, theft by taking and battery?
Guilt.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, ma'am.
Your Honor, the state believes that evidence would show at trial that on June 1st, 2021, at 445 Cleveland Avenue in Atlanta, Georgia, in Fulton County, that the Atlanta Police Department was dispatched to that location in regards to a domestic dispute. At that location, the victim, Miss Lakeisha Wilburn, explained that she came at her family member's residence to drop off Mother's Day gifts. She had to return to her vehicle for more items, and at her walk back to the vehicle, she was encountered by her boyfriend, Mr. Willie Lee Turner, the defendant. She stated the defendant struck her in the face several times, and that he forced into her vehicle. He took her vehicle, which included her purse. Her purse had some about $700 cash and her bank cards. And then he did leave that location. Officers later recovered that vehicle, which was a 2012 black Ford Escape valued at just underneath $25,000 at an intersection. It appears to be abandoned at that time. Your Honor, we're making a recommendation for the defendant to be sentenced to 5 years to serve 4 months in custody, that the balance of that sentence be on probation, that he complete an anti-theft course, complete his GED, 40 hours community service. And that's on the theft by taking, and then for the battery for him to be, for him just to serve 4 months.
Okay. This case is less new than some. Any contact with Ms. Wilburn about restitution? You mentioned there was $700 in cash in her purse. And I know that she got the Escape back, but what shape it was in, anything like that?
It looks like our office has not made any recent contact with the victim. We did speak with her many years ago in regards to this case. There's no indication about restitution for the money that was in her purse.
Okay, and you're not Ms. Wilburn?
No.
Nope. Oh, okay. All right. Well, I'm glad you're here for him. I just want to make sure we weren't missing an opportunity to get input. Okay. So nothing on restitution at this point.
No, Your Honor.
All right. Thank you. Let's hear from Ms. Jackson. I do note that Mr. Turner was a repeat offender. This case had been in the non-complex division and got sent here. So I've seen a list of convictions from a fairly long time ago. What else do you have, Ms. Jackson?
There are 37 cycles. The last arrest was December the 31st, 2024, out of DeKalb County for a failure to appear. He does appear to be on probation in Gwinnett County for interference with government property. That disposition date was October the 14th, 2022, and the term is for 5 years. He does have prior felony convictions, one in 2017 out of Gwinnett County for theft by taking, one in 2015 for felony obstruction an officer. So an additional one in 2015 out of DeKalb County for theft by taking, one in 2000 out of DeKalb County for possession of controlled substance. And there are misdemeanor convictions and sentences, if you'd like to hear those, Your Honor.
I'm good with what you shared. Thank you for asking.
Okay?
Ms. Wood.
Thank you, Judge. Mr. Turner is 44 years old. He is a resident of the Atlanta area. He has a ninth grade education. He does have a GED. He informed me he just completed the Serve Safe Management Program at the DeKalb County Jail. He's actually been there since that December 31st arrest. Mr. Turner actually wrote our clerk over the summer to get her to resolve the case.
I saw something
Yes.
in the docket saying, hey, I'm here well, I'm nearby. Could you get
Yes.
me here? Okay.
So Judge, he has been eager to resolve this case. He has no issue with the no contact and the stay away order. He's actually done 96 days in our jail if you add the booking dates up. But then, of course, he's been in custody, so he should have the 4 months completed. His mother is present. Judge, he's just asking that you accept the state's recommendation.
Okay. All right. Mr. Turner, do you have any questions about anything we've discussed?
No, sir.
Ms. Wilburn was your girlfriend back then in June of 21?
Yes.
Okay. When did you last have contact with her?
Probably like 3 years ago.
Okay. So she's been able to go her own way.
Yes.
All right. Do you have any kids?
Yes.
How many kids?
5.
5 kids.
Yes, and 1 grandchild.
And a grandkid. Okay. What's the age range of your kids?
27, 25, 19, 16, and 11.
Okay. The 11-year-old is a boy or a girl?
A boy.
And where does he stay?
He stay with his mother.
But where's the?
All indicator.
Okay. Are all of your? I mean, some of them are grown, but are they?
My oldest one. My 3 middle ones is by my wife, and I have one when we separated.
Okay. And Ms. Wilburn's not your wife?
No.
Okay. But the 11-year-old is the 11-year-old is with his mom in Decatur, and the others are where they are, but they're local-ish.
Yes.
Okay. All right. And you already got your GED.
Yes.
When did you do that?
I went to RSAT.
You went to RSAT?
Yes.
Okay. And while you were at RSAT, you got your GED?
Yes.
All right. You got some proof of that?
Well, they didn't. I didn't know. I don't have it.
All right. How would you document? Because one of the requests of the state was that you get your GED.
I should be able to pull it up, go online.
Okay, good. That's all you'll need to do. I'm not going to have you do it twice, but you saying you got it isn't probably enough. You're going to need to direct probation to that, however you can do that. And there's got to be a record of it if you finished it while you were at RSAT. So I'm sure you can figure that out. All right. Well, I find there is a factual basis for your plea. That your plea was knowing and voluntary. When was RSAT after this situation or before?
Before.
Before. How long ago was that?
I think like 2017.
Okay. And that was just part of a sentence you got for one of these cases we heard about?
Yes.
And was that through probation or was it through Department of Corrections?
Probation.
Okay. All right.
No, they were through correction.
Right. You went down to Jackson, got designated somewhere, and ultimately did RSAT through Department of Corrections.
Yeah.
And did you successfully complete RSAT?
Yes.
Okay. So, like I said, I find a factual basis for this plea and that your plea was knowing and voluntary. Ms. Wood, can we sign the indictment for you, someone in my office?
Yes, Judge.
And Ms. Davis?
Yes, Judge.
Mr. Turner, it's okay if someone signs your name to the indictment, indicating your guilty plea. I will sentence you on count 1 to a term of 5 years to serve 4 months with the balance on probation. And count 2 is 4 months to serve. That'll run concurrently with count 1. Special condition of probation number 1 is that you complete 40 hours of community service. You'll need to do that within the first 8 months of probation. Number 2, no contact with Ms. Wilburn. That should be pretty easy if you guys have been apart for 3 years. Number 3, complete an anti-theft course. And then number 4, complete the GED or provide proof of completion. And if you can show that you already did it, then you don't need to do it a second time. Do you have a place to stay when you get out?
Yes.
Where's that going to be?
Me and my girlfriend, probably in the cab.
Okay. Now you mentioned a wife. Are you also?
Yeah, we've been separated for
Okay.
a while.
But that's not who you'll be staying with?
No.
And a girlfriend's not Ms. Wilburn?
No.
Okay. And you've been in nonstop since December?
No, I've been in since December. Yeah,
Right.
yes, nonstop.
Yeah,
Yes.
okay. You got picked up on that FTA, basically New Year's Eve,
Yes.
and you've been in either DeKalb or here since then?
Yes.
Okay. I know you're on probation in Gwinnett. This will not be a basis to revoke that probation because this incident is actually before your Gwinnett conviction. My hope is that all this stuff, this is old, your convictions are pretty old, reflect who you used to be and not where you're heading. Because with this probation hanging over your head and your criminal history, if you're still working through things, probation could be a little bumpy.
Yeah, the probation in Gwinnett, actually, I was terminated from that.
Oh, what happened?
Correct, that case expired.
Oh, it expired. It must have been a short.
He's on probation here with us, Judge.
Oh.
He actually has a probation warrant that he needs to have on probation.
Connected to this or something
That's
different?
connected to this as well as he picked up a Gwinnett County charge.
Oh, what is the Fulton County case?
18 SC 157643. It's a Judge LaBue case.
Oh, all right. So was it like 400 years probation?
No, actually, it was only about, did the math up, added together, came up to about 16 years.
Okay. All right. So the basis for the revocation is because that's an 18 SC case, this arrest / conviction, and then something new that you have in Gwinnett County. New meaning pretty new or all this stuff is so old?
Yeah, it's pretty much around the same thing, around the same time. The Gwinnett one took place October of 22. And then this one took place August 22.
When you say this one, this was a June 21 incident, but
The Gwinnett was October 22.
okay. All right. What do you want to do with the revocation?
Handle it.
Okay. And what are you recommending?
Revoke 4 months.
And reinstate the balance?
Yes, Judge.
Okay. Any issue with that, Ms. Davis?
No, Your Honor.
All right. So, Mr. Turner, I'm going to revoke 4 months of your probation in 18 SC 157643 based on your conviction in this case and your arrest in that Gwinnett case. I don't know what happened with that case, but just getting arrested is a basis to revoke. But that'll take care of that warrant that's hanging out there. And you're not on probation in Gwinnett anymore, so you'll just be on probation for this case, but it sounds like you're going to be living in DeKalb?
Well, my mom stays in Fulton County, so right now, I will have an address for him though.
Well, you don't just get to pick a rent, like you don't get to pick my address, which is in Fulton County. It needs to be where you're staying because probation, you've been through this before. They're gonna come visit you, and if they show up at your mom's house and she says he lives with his
I
girlfriend.
can get on my mom's address until further notice. I'll let them know,
Well, that means that you'll be staying at your mom's house.
Yeah.
Okay, so when you get out, you plan on staying with your mother. She may say enough, and if you move, that's fine. You let probation know, but that means your probation will start out in Fulton County.
Yes,
Okay. What's the zip code of your mom's house?
30315.
All right, that's very Fulton County. I don't think I've got anything else then. We took care of the probation revocation, your sentence. Anything more from the state?
No, Your Honor.
Ms. Wood?
No, Judge, thank you.
All right, Ms. Simpson, what do you need to share with Mr. Turner?
Report to maintain his probation officer within 48 hours.
But I thought he didn't have a probation officer because his Gwinnett probation was terminated?
Already on probation, that's.
Oh, in this 18 SE case that we just revoked. All right, you know who your probation officer is?
No, because I had my supervision was in Gwinnett.
I'll give it to you.
Okay, you're gonna get that contact information. It'll get shifted to Fulton, so long as
When
you're,
they terminated it,
hmm?
I guess when they terminated it,
I don't know. But you'll get some contact information. You need to call that person when you get out to say, hey, I'm out. I need to get signed up for this new case, the one you just pled to. All right, and you're gonna be on probation for 2 cases, your old Fulton case, as well as this newer Fulton case. And then maybe you can be done
thank you, sir.
getting arrested for stuff.
Yes,
That'd be nice. I bet your mom would appreciate it.
most definitely.
She says, yes, this is not where she wants to be, watching her grown son in the blue jumpsuit.
Thank you, Judge.
You're welcome.
Right, here you go, Mr. Turner.
All right.
Good luck.
This is your name. So whenever you get out, because you gotta go back to CAP, this is the address you need to report to here, okay? So, got it?
Sounds so.
So this Marcus Moment guy has all sorts of names on it that aren't yours. Are you handling Marcus Moment?
Yes.
Okay.
Bye, Mr. Turner. You're welcome. Good luck. You got a lot going on.
Yeah.
So I think Mr. Moment is the last one. We've got our DOC one, but that doesn't involve any of you, and that will be this afternoon when we take care of the revocations.
I'm
Okay,
ready, Moment.
all right. You good to go with Moment?
Yes, I'm ready.
Excellent.
All right, slide over. So if I ask you anything you don't understand, just let me know. We'll step away for a minute, okay?
All right, let's turn to Mr. Moment. Good morning, Mr. Moment.
Good morning.
How are you doing today?
I'm all right.
Good. Mr. Moment, you've got 2 cases, and Ms. Wood tells me you're ready to enter pleas in both of them. Is that correct?
Yes, sir.
Okay. In a moment, Ms. Davis will put you under oath and ask you questions about both cases. You need to answer those questions truthfully and completely. I also need you to let me know if at any point you've got a question or you're confused by something that's going on. Will you do that?
Yes, sir.
Okay. This is 24 SC 005160 and 25 SC 002350. Ms. Wood represents you on both cases, and Ms. Davis is handling both for the state. When you're ready, Ms. Davis.
Mr. Moment, please raise your right hand. Do you swear or affirm the testimony that you will give in this matter before the court shall be the whole truth and nothing but the truth?
Yes.
You can put your hand down. Please state your true, correct, and legal name.
Marcus Jarrell Moment.
At this time, are you under the influence of any alcohol, drugs, or medication?
No.
Is there any medication that you normally take that you have not taken today?
No.
How old are you and how far have you gone in school?
32 GED.
Are you able to read, write, and understand the English language?
Yes.
Are you a United States citizen?
Yes.
Do you understand that you're charged with the following offenses in indictment ended in 160, criminal attempt to commit a burglary, possession of a firearm by a convicted felon, no headlights, possession of an open alcohol container, a failure to obey traffic control devices, driving while license suspended, failure to maintain lane, and knowingly driving a motor vehicle with suspended registration.
Yes.
Do you understand an indictment ending in 350 that you're charged with fleeing or attempting to elude, driving under the influence of alcohol? I believe count 3, which is also a count of driving under the influence of alcohol, would merge, Judge. Count 4, speeding, reckless driving, and possession of an open alcohol container.
Yes.
You understand that you have the right to plead either guilty or not guilty to these charges, and if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your lawyer, Attorney Wood, about all the facts and circumstances known to you regarding this indictment, including any potential defenses?
Yes.
Do you need more time to discuss this case with your attorney?
No.
Are you satisfied with her services?
Yes.
Attorney Wood, do you waive formal reading of the indictments and any and all defects therein for the purposes of this plea?
We do.
Mr. Moment, do you remember being arrested on these charges?
Yes.
Your Honor, the state's unaware of any outstanding warrants related to both of these matters. Attorney Wood, are you aware of any outstanding warrants related to these matters?
I'm not.
Mr. Moment, has your attorney advised you of the minimum and maximum sentence for each charge to which you are pleading to today?
Yes.
Okay, for the indictment ended in 160, criminal attempt to commit a burglary, the minimum is 1 year, the max is 10 years. For possession of a firearm by a convicted felon, minimum 1 year, max 10 years. For all of the misdemeanors, including headlights, failure to obey a traffic control device, driving while license suspended, failure to maintain insurance, and driving on a suspended registration, the maximum is 12 months. For an open container, the maximum is a fine up to $200. An indictment ending in 350, fleeing or attempting to elude, the minimum sentence is 12 months. The max is 10 years. For driving under the influence of alcohol, the maximum is 12 months. For speeding, reckless driving, the maximum sentence is 12 months. And for an open container, it's up to $200 fine. Do you understand that?
Yes.
Do you understand that today you're entering a negotiated plea of guilty, which means the state will make a recommendation to the court?
Yes.
Do you understand the court is not required to accept the state's recommended sentence?
Yes.
Do you understand the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
Do you understand there are multiple charges to which you're pleading guilty today, and the court has the right to run those sentences consecutively or one after the other?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of that sentence?
Yes.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that this plea or these pleas may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including federal courts?
Yes.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that is true regardless of any advice by your attorney or anyone else?
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you'd be guilty of a felony which can carry a sentence from 1 to 15 years in prison?
Yes.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights? And I'm going to go over 9 and then ask, do you understand, okay? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 4 years from today for the felony charges and 12 months from today for the misdemeanor charges to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
How do you plead to the charges in indictment 160, criminal attempt to commit a burglary, possession of a firearm by a convicted felon, no headlights, open container, failure to obey traffic control devices, driving while license suspended, failure to maintain insurance, and driving with suspended registration?
Guilty.
How do you plead an indictment ending in 350, fleeing or attempting to elude, driving under the influence of alcohol, speeding, reckless driving, and possession of an open container?
Guilty.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Your Honor, the state believes the evidence which would show in indictment 160 that on August 8th, 2024, officers were dispatched to 2124 Cheshire Bridge Road in Atlanta, Georgia, in Fulton County for a prowler call. Upon arrival, officers made contact with the victim, Ms. Myrtle Legaspi, who stated that an unidentified male was at her property and attempted to enter her apartment. He attempted to open a window. Once he noticed that she was inside, basically said, "Oh crap," and fled the scene.
He really said, "Oh crap"?
Well, he actually said something else, Judge, but
Okay.
I won't say that in court.
Okay.
The victim was able to capture Mr. Moment on the Ring doorbell camera. She provided that camera footage to the officers. Officers canvassed that area and noticed that there was a BMW that sped out at a high rate of speed when they were arriving. Other officers did make contact with that vehicle. He began to drive recklessly. He had no headlights on. He continued at a high rate of speed and ended up in a car wreck. The vehicle did not have any active insurance and the registration was suspended. They did observe a container, open container of Maker's Mark whiskey. In indictment ending in 350, on September 3rd, 2022, officers were dispatched to the location in regards to a black sedan traveling at 101 miles per hour in a 45 mile per hour zone. They attempted to initiate the stop. The vehicle continued to drive. It did lose control, it struck a median. After the median excelled again, at that point, they said there were sparks flying under the vehicle, but at some point, the vehicle did come to a rest, and the driver was ordered at gunpoint to get out. They searched the vehicle. They did locate a cup, a Quick Trip cup, with some type of alcohol that was inside. The defendant did admit to consuming 2 beers prior to driving, and he did smell of alcohol. And that incident location was at Fairburn Industrial and Howell Avenue in Fulton County. For 160, the state is making a recommendation of 7 years to serve 1 year, the balance on probation, for the defendant to complete a defensive driving course, drug and alcohol evaluation, plus treatment if required, 60 hours community service, GED or provide proof, to have no contact with the victim, Ms. Myrtle Legaspi, and to stay away from the incident location, which is 2124 Cheshire Bridge Road in Atlanta, Georgia. It's my understanding that they did not know each other. The victim, I did speak with her. She believes it was a mistake, but he did repeatedly try to enter her property, and so she was terrified, but they don't otherwise know each other. And I guess as far as the sentence, I would be asking the court to consider for the defendant to have a sentence of 12 months to serve on all the misdemeanors, with the exception of the open alcohol container. And then for the 7 years to serve 1 to be on counts 1 and 2, the criminal attempt to commit a burglary and the possession of a firearm by convicted felon to run concurrent.
Okay.
For indictment 350, we're requesting that the defendant be sentenced to 5 years to serve 12 months. For count one, fleeing and attempting to elude, 12 months to serve. And then for the misdemeanors to be consecutive to the fleeing and consecutive to each other. And so that would mean the DUI, 1 year or 12 months probation. Speeding, 12 months probation consecutive to the DUI, reckless driving, 12 months probation consecutive to the speeding, and then a fine potentially suspended for the open alcohol container in this case, with all the same terms and conditions of the other ones, which is why we incorporated the drug and alcohol evaluation, because I believe that's required for the DUI. Also, I believe there is a minimum $300 fine that's required for the DUI as well.
Okay. Any reason why the sentence in 350 is not just 7 to serve 1?
I don't think we can get there.
I thought
I guess maybe 6, maybe 5.
Well, I thought you said the range, and I may have written it down incorrectly, for count one was, you said 12 months because it's that funky statute, but I thought it was 12 months to 10. Is it 12 months to 5?
It's 12 months to 10, Judge, but the way we've had discussions in our office, it's my understanding that it can't be probated. It's my understanding that if it's probated, it would be a not valid sentence, that it has to be in custody time and it cannot be probated. Well, I would defer to the court, but that's my understanding.
Well, I want to get it right. I thought that well, I'm going to take a look at it. They don't need to be the same. I just was curious why they were different. There's not a requirement that across 2 cases, the sentences are identical. So let me look.
I believe the office's position is he could be sentenced to serve 10 years, but we could not probate any portion.
You couldn't do a 7 to do 1 on that. It would be 7 to serve, which is not what anyone's talking about.
Correct.
Okay. Okay. It is, the legislature needs to rewrite
Yes.
part of that.
Yes.
Thank you for sharing all that. Ms. Jackson, do you have any criminal history information on Mr. Moment?
Yes, Your Honor. There are 23 cycles. The last arrest was July the 28th, 2025, out of Douglas County for a probation violation and riot in a penal institution. There was no disposition for that arrest. He does appear to have multiple open probation cases. The first case is out of Cook County, Georgia, for identity theft fraud and possession of marijuana with the intent to distribute. That disposition date was February the 7th, 2020, and the term is for 10 years. Second case is out of Clayton County for criminal damage to property in the second degree. That disposition date was January the 27th, 2025, and the term is for 5 years. The third case is out of Douglas County for possession of a firearm by a convicted felon and fleeing or attempting to elude an officer. That disposition date was October the 18th, 2023, and the term is for 5 years. There appears to be an outstanding hold out of Adele, Georgia, for a probation violation. The date on that warrant is August the 29th, 2024. He does have a prior felony sentence and a conviction. He received first offender treatment in 2018 for theft by receiving stolen property. That case was sealed April the 21st, 2022. There was a conviction in 2016 out of Florida for fraud and grand theft. Nothing in addition, Your Honor.
Thank you, ma'am. That's a lot of cases for which you're on probation. Where's Adele, Georgia?
Cook County.
Cook County, they want to see you. Okay. Ms. Wood.
Judge, I know this is negotiated, but given some information I learned from Ms. Simpson, I'm gonna just let the court know it may make more sense for us to change the structure of this sentence.
Okay.
He does have a Cook County hold that's actually showing, I believe there's now a Douglas County hold and perhaps a Clayton County hold soon to be coming down the pipeline. So the 25 SC 002350 case is actually the older one. It's a September 3rd, 2022 incident. He was here in Fulton County Jail for 4 days. He went directly to Cook County Jail. He was there for about 240 days. Then he went to Bay County, Florida. Then he went to Clayton County. He was able to get out. That's when he picked up the 24 SC case on August the 8th, 2024. He was in our jail for 64 days. And then last fall, he went directly to Douglas County. He came from Douglas to here earlier this year and then back, and then he came directly here from Douglas 36 days ago, Judge. And now that I know that the Cook County hold is back in place, I realize he's not going anywhere anytime soon. So I share all of that with the court to let you know that it may make more sense for us to restructure the negotiation.
Okay, to what?
Well, I believe he gets credit for most of this time. So if the court would prefer to do a straight sentence, or if the court wants to have the probation there, I just don't know when he's going to be able to actually report to probation is my concern.
Got it. And let's find out this. How much are you able to tell Ms. Simpson of the 3 cases for which he's on probation, which, if any of them has a particularly long tail? Like, will he be on probation for a few more years, or these?
So Cook County ends December 18th, 2029. Clayton ends October 8th, 2029. Both his Clayton cases end October 8th, 2029. And his Douglas case ends April 18th of 2028.
All right, so there's 3-ish, 4-ish more years of probation there. Okay. So what I think I'm going to do, well, Mr. Moment, do you have any questions about anything we discussed?
No.
Where's home for you? If you got out today, I magically said, free pass. You don't have to go to Cook or Clayton or Douglas County. Where's home?
Atlanta, Georgia. My address is, I don't know if you could see it on file, but it's the 4946 address.
I'm sure it's in there. So Atlanta. So what's in Cook County? What's in Clayton County? What are you doing out in all these other places?
Honestly, I had warrants from situations that were already discussed.
Mm-hmm.
And I ended up in situations in these counties just passing through.
Just passing through.
Mm-hmm.
Why were you passing through these counties?
Going to visit friends, just different miscellaneous reasons, you know.
Okay.
Having those warrants, of course, you know, getting flagged by the police and
there you go.
Being ready to go to jail yet.
So then it's a chase. One of the counts in the older case, newer indictment, said you were driving with one tire. I guess after you hit the median, the wheel came off or something. Is that why sparks were coming up?
Yes, sir.
Okay. And were in either of these instances, were these your cars or someone else's cars?
My cars.
What kind of work do you do when you're not in one of these many county jails?
I'm an electrician, and I've done production work in the music industry and stuff.
Okay. You're like a licensed electrician, or you just taught yourself how to do it?
No, I actually went to school for it.
Okay. So home is in Atlanta. Who's in that house now?
Just me.
So it's just empty?
I mean, no, my mother's staying there now, but, you know, for the most part, it's just me when I'm home.
Okay. But you haven't been home for a while. You're not going home right away. So your mom stays there?
Yes, sir.
Okay. All right. You have any kids?
Yes, sir.
How many?
1.
How old?
8.
Boy or girl?
Girl,
And where's she?
she's with her mother
Which is where?
in Atlanta.
All right. And mom is in Atlanta. Okay. You got any questions about anything?
No, sir.
Okay. Well, I find there is a factual basis for both your pleas, and that your pleas are knowing and voluntary, meaning you've understood what we talked about and that no one's forced you to enter these pleas. Do you agree with that?
Yes, sir.
Ms. Wood, can someone in my office sign the two indictments on your behalf?
Yes, Judge.
Ms. Davis?
Yes, Your Honor.
And Mr. Moment, can we electronically sign your name to both cases indicating you're guilty, please?
Yes, sir.
All right. So what I'm going to do on 24 SC 005160 is sentence you to 1 year and 6 months on counts 1 and 2. Run those concurrently with each other, and then 12 months to serve on the remaining misdemeanors. I don't think there was. There's no, oh, there was an open container. So it's 12 months to serve on count 3, 5, 6, 7, and 8. Those will all run concurrently with count 1. And then count 4 is a $200 fine. In the 25 SC case, your sentence on count 1 is 1 year and 6 months to serve. Count 2 is 12 months to serve. 3 merges into 2. 4 is 12 months to serve. 5 is 12 months. 6 is 12 months. They all run concurrently with count 1. And count 7 is a $200 fine, and there's an additional $300 fine for the DUI. So it's a total of $500 in that case, $200 in the other case. These are all purely custodial sentences. I'm not going to try to calculate how much credit you get. Not my job, and I'll get it wrong, and they'll just send it back. Ms. Wood can help you process it, but you're going to want to be getting paperwork from all the different places you've been. You're entitled to credit for time you've been locked up, even if it's a different offense, while these charges are pending, and that credit will go towards the 1 year and 6 months that you need to serve. I think probation makes a ton of sense, but you've got it in these other counties. And if you end up residing in Atlanta, it's all going to be supervised in Fulton anyway. But if you have a violation of probation, that won't come back to me because I'm not giving you any probation. It'll be go to Cook, go to Clayton, go to Douglas. Ms. Davis, anything else from the state?
No, Your Honor.
Ms. Wood?
No, Your Honor, thank you.
Okay. I think the recommendations made a ton of sense, but with this existing probation and the fact that Mr. Moment is probably going to visit each of the 3 counties to deal with revocations there, we can just impose the year and 6 months time. And if it doesn't add up to a year and 6 months that you've already served, you'll do all of it courtesy of your fleeing and attempting to elude in the more recent, the more recent incident is the slightly older indictment. Nope, it's the other way around. It's the older incident and a more recent indictment. I think that's it. So thank you, everyone. Ms. Jackson, we're going to be back on at 1:30. If you don't mind rejoining us for the 2
Judge, do you have something to go do right now?
Okay.
I'm asking, do you have something to do?
I'm good for another 20 minutes.
Can you have them up in 20 minutes? Because the 2 on the afternoon calendar are super quick.
Oh, okay. Then sit tight, Ms. Jackson. But we will be reconvening, I think. Ms. Nelson, do we have confirmation yet from the lawyers that we can do that plea this afternoon?
I have everyone confirmed except Mr. Nelson, so I will reach out to him one more time. But DLC is going to join the defense as well as Hines, so.
Okay, well, we can just all pop on at 1:30, and if we got Mr. Rhodes, then we can knock out that plea. So we're bringing out Roberts or Nolly first?
We can do, Robert's can come to the door and then we can do Mr. Nolly.
Oh, well, this first one's really quick.
Yes. Oh. Well, let's see.
Wait, you're not having me swear you in? After all that? That's so rude. Who's swearing you in?
Judge Esmond Adams.
All right. I'll remember that. And you will too.
Oh, okay.
He does. Mhm. Oh, okay, so this one's gonna go to conflict. Okay.
Oh, Mr. Roberts, you can't help him.
Correct.
Okay.
That's why he's going to the door only. I'm not sure.
Who, and so do you reach out to Mr. Luemba? Because my recollection is that Euphemia says, I don't do revocations. Not in that tone, but.
Correct. Yes, and we emailed Joanne last week to figure out who, because I know the two new cases were already assigned to conflict. So we'll figure out who's going.
Well, and you know, this case is actually not our case. The thing he's being revoked on, it's because he's being revoked in connection with new charges. And so when I saw it and I looked at this, and I don't remember this guy. And look who signed the warrant. I didn't. But it ought to be here because it's been indicted. But then I didn't know if, okay, he's going to plead to the new case, this 25 SC. Which is some stolen, it's theft stuff. Oh, this is the guy. Oh, he had some issue. He's a co-defendant with, yeah.
Gary.
Yeah, Garyana Stone, and Rio says that he wouldn't come. Debbie Gordon wouldn't even bring him up for his arraignment. He was acting out down on the.
Oh.
Gordon said it was so bad, because he asked, he was like, is he gonna bring it in? He was like, no, he was like.
Yeah, I'm not bringing him up.
Yeah, he was like, I'm not bringing him up.
Yeah.
The great co-defendant. Y'all got, well, you had the good one.
Yeah. And then Mr. Nolly is 160 days, I think is the time he's been in.
He's got a co-defendant in that other case.
Oh.
Robert?
In both of his, he has two cases with it.
A co-defendant with this stone and
Yeah.
a co-defendant in one, and then he has a co-defendant in the other.
Okay.
Interesting.
Yes.
Okay, yeah, and I'll just put a little bit of information on the record for the judge about why.
Perfect. Excellent. Thank you.
Did the deputies, what are they doing?
They were taking people down and then bringing.
Oh, these folks weren't up because they were afternoon. Okay. I'm doing a little mock trial tomorrow morning at Georgia Tech with engineering students. They're purely engineering students. They're learning how to build cranes that move freight around in freight yards. But their professor wants them to think about sort of the real life of what happens with this stuff. And so it's a fact pattern where one of the big shipping containers accidentally is dropped by the crane on a truck and someone is, I don't know if he's killed or injured, and they have to argue, but they're dealing with expert witnesses. So it's not so much, do you know what liability means? It's handling expert witnesses, experts in the engineering field that involves moving these cranes around.
Nice.
Yeah. I don't know how they found me, but Georgia Tech, usually, it's Emory, it's Georgia State. It's like,
Telling you, you're popular.
well, I don't know how this engineering professor found that, but it'll be interesting. And then we've got a jail Zoom calendar. Haven't done that in a minute. Do you have anything on the trial calendar that is looking like it'll go? It's lots of private attorneys. Let me see. Let is supposedly going to behavioral health.
Yes.
We just need to get that lawyer in the mix. Did we already resolve Julian Terry?
We didn't. We're waiting on their motion, and then I've had my investigator reach out.
That's on me. That's on me. It's because of Tevis. Okay.
Yeah,
Right.
but we're still
Okay.
supposed to be working on our piece, and I've seen emails, I've seen requests. I'm gonna ask.
Oh, meaning
Archie
that
Britton to
they're
be
not
involved.
getting,
That
got it.
additional evidence that
Okay.
you said that we should take care of.
Okay.
And I think that might have been why you had an asterisk on ruling on that motion, just to see what we were able to get and if you needed to review it. Like one of those was like the tactical plan.
Oh, right.
You need to review it
Because
first.
part of it is, do you reveal the CI?
Correct.
What about Ms. Kurt's 3 cases? Mr. Martin?
I haven't talked to her or spoken with her since the final plea, but I thought it was going to be resolvable.
Should be. I hope so. All right. And then that's Ms. Clark's case. John and Willis we're resolving hopefully today. Got Ms. Rockwell's client.
Yes.
How about number 18? Oh, I don't know if you've got the calendar. I don't mean to be.
That's diversion. I do.
Oh, that was a diversion? Okay.
Like you did.
Your program or the?
The DA's office one.
Yeah,
We've
that's what I
already
meant.
ordered.
Yeah, okay. Great. And then Carter Jackson is being evaluated. Ulysses Greer.
That was the one, I believe he was being evaluated.
Hmm.
That's
Okay.
a rare case. I think it was supposed to be an evaluation.
I wonder if she didn't, or if it's sitting in my inbox.
That one was like right before she left.
Okay.
Yeah, I think that came up. So maybe evaluation. And then I think depending on that, it was supposed to be non-negotiated, I think. She wanted it to be negotiated. I just don't know where she is with it.
Right. It's not coming up. Okay. Gosh, so there's not much left. It really is, even if I didn't want to, it would be gentle.
Yeah, because I think Perry's still surgeries.
Yep.
And she's on leave next week.
All right. So Ms. Kurt, you and Ms. Kurt need to figure out what's happening there.
Call her.
Okay.
Trish, I think I've asked you this before, but Do they do work release here at the jail? Your jail, Fulton County Jail.
Our jail,
Oh,
meaning like I could go to work and then come back in the evening.
correct. So
Judges have tried doing that and the sheriff has said, please don't do that. It's the process of booking it. The closest we do is weekends in jail. And so we release you for the week to go work. I get it, just because of the person power involved of processing people in and are we booking you in each time? Not really. I kind of live here. If we don't have substance abuse concerns, Georgia Works is a program that we should look at more where they provide housing and construction training, things like that. But we don't have a halfway house option, unfortunately. But when you say your jail, do you come from some jurisdiction where you could do that? You act like, well, I was in Cook County, we did that.
in Clayton County, when I was a defense attorney, they did that.
Really?
They just would go, they would live at the jail
Yeah.
at night, they would go to work. It was always for someone who had a real legitimate job.
Yeah. And you could
just left
document
their
it.
vehicle- They left
Yep.
their vehicle outside.
Yep.
Come in, in the morning, report to work, come
Yep.
back and spend the night there. So it was
Yep.
a good little easy resolution. And I was also asking because you all have access to many jails. It seems like you put different inmates in different places, like maybe the Atlanta jail could do it or Southland Annex.
So there are inmates housed in different places. That's more of a jail space issue. So there are some inmates in Oconee County and in Cobb. Those are the two main places. The South Annex is not where you'd want to be. That's where they send the problem people.
Okay.
So that would not be work release. That would be work punishment. That's where Mr. Tewitt went for his last night in paradise. The city jail is a potential good idea. Asterisk, that lease is up and there's lots of uncertainty about whether it will be renewed. There are pressures in both directions.
Sure, for sure.
So now wouldn't be the time to approach the sheriff and say, hey, what about work release using the city jail? Because his response would be, get me to city jail. I'll talk to you about it.
Yeah. Okay. I hate that though, because just one person, I just feel like.
Nope, it's a great concept. And it would fit a not small number of cases where I got this job, I don't want to lose the job because it allows me to pay for X, Y, and Z. Let's let the powers that be sort out what's happening with the city jail, and then it may be time to approach.
Understood.
We'd like to have Mr. Roberts come to the door. Are you Mr. Roberts? Hey, Mr. Roberts, I'm Judge McBurney. You've got a couple cases assigned to me, new cases. You also have a revocation. You took a plea in front of Judge Ingram. But the basis for your revocation is one or both of your new cases. So that revocation is coming to me. Today was just to talk about that revocation. And then Ms. Wood realized, I can't represent Mr. Roberts because her office represents your co-defendant in one of the cases you've got with me. You got a case where there's a co-defendant named Ms. Stone, Garyana Stone, and she has the public defender as her lawyer. They can't represent both because Ms. Stone may be saying things about you and then they know things about you. So what we're going to do is figure out who is a lawyer who can focus just on you, represent your interests and your interests alone. And then that person can talk to you about, hey, you got two new cases and a revocation. Do you want to try to work them out all together or deal with them one piece at a time? I'll do whatever the lawyer says. But we need to get you that lawyer and get that person to spend a little time with you and then let me know what we're going to do with your situation. Okay? It is getting reset because we need to get you that lawyer. Okay? Any questions? Okay. And then Nolly can come all the way out. And Ms. Wood, your office is looking to get, I think the easy answer for the revocation will be whoever gets assigned his two cases, and that ought to be Ms. Cabrera, but I will let Mr. Luemba work through that. Has your office pushed the two cases
Yes.
through that pipeline?
Yes, and as of October 7th, this one was supposed to be going directly with those two. So as soon as I have that name, I'll share it.
Okay. All right, let's get on the record in State versus Nolly. This is 24 SC 002-573. Mr. Nolly, good morning.
Good morning.
You are here in court because I signed a probation warrant for you in June of this year. It alleged that in April of this year, you were supposed to report to probation, you didn't, and then just a few weeks later in May, you were arrested for possessing a little bit of marijuana, a lot of something else, and driving with no license or a suspended license. And we need to work through that. You're under sentence for having had some drugs. And so I think the state wasn't going to view this as just a minor situation. In fact, we may have had a court date already in this, and Ms. Wood asked for a little more time. Actually, she said we want an evidentiary hearing, which means the state was given time to get the officers here to do that. But it sounds like we're doing something different today. I'm going to find out how much time remains on your probation. Then I'm going to hear from your lawyer and anything you want to add. And I'll hear from the prosecutor and we'll make a plan. Okay? Ms. Simpson, how much time remains on Mr. Nolly's probation?
9 years, 5 months, 1 day.
All right. Just less than 9.5 years. Ms. Wood, is Mr. Nolly admitting to the arrest, or where are we? And there's also the technical violation. Where are we with all that?
We are admitting to the arrest only.
Okay.
And then, of course, the technical violation as well, Judge.
All right. Given those admissions, what are you recommending happen with Mr. Nolly's probation?
We are asking for the court to revoke the time he's been in, which is 160 days, and then reinstate him to probation.
You said 160?
Yes, Judge.
All right. Ms. Davis, your thoughts?
Yes, Judge. I'm in agreement. I did have the opportunity to review the body camera from this incident, and I believe the state would have a hard time proving that the search that turned up the drugs was lawful. I've actually spoken with my supervisor, and I probably will be moving to dismiss the case.
Oh, has it been indicted?
No.
No, so you'd be NPGJing it or whatever the
Yes.
process is.
I actually was working on the indictment, but pursuant to the video, it was a valid traffic stop. The officer did have probable cause to search the vehicle based on the smell. He did recover what he smelled. Then he also took the defendant's key from around his neck and unlocked the glove compartment. And so that, I think, throws the drugs out. And so we believe the time that he has been in custody is more than enough for just the traffic violations. And so I believe that he should just be returned back to probation.
Okay. What is your driver's license status, Mr. Nolly?
It was child support.
Meaning it had been suspended because you owed child support?
Yes.
It wasn't because you had too many tickets or something?
It was child support. Child support. I hadn't paid my child support.
Okay. How are you doing with child support now?
Now, when I get out, I start paying when I get out. I'm good. Right.
Okay. What do you do to earn child support money?
I'll be working. I work and they take it out.
Can you hold your chains tight?
They take it out my check automatically.
Okay. But when you say you're working, what does that mean? What do you do?
I start back working.
Right. But doing what? Are you a doctor?
Yeah, now construction work.
Construction work.
Yes.
Okay. What kind of construction work?
Like labor.
Okay. But do you build or you tear down?
I tear down. and I'm a laborer.
Okay. And do you have a particular firm you work with, or you use like one of those apps and like, hey, they need someone?
I was working with Baskin Cook Construction.
Okay. Do you think you can go back there?
Yes, sir.
How long had you been there?
I was there about 2 years.
Okay. All right.
But he told me when I get out, just come back and fill out another application. He'll have me back.
Okay. This key around your neck, was that the key to the car, or you have a special glove box that has its own key that you wear around your neck?
Nah, that was the keypad.
Key to the vehicle.
The key to the car?
Yeah.
Okay. And you wore that around your neck?
Yeah, it's like the keypad of the car that had to hang around my neck. It's a push button.
Got it. Okay. And that opens the glove box?
And now you have to take it apart.
You have to take what apart?
If you push a button, if you unlock it, it takes up the key part and you use that to.
Okay. And it was a locked glove box?
It was a locked glove box.
Okay. All right. You were supposed to report to probation and you didn't. What was going on there?
When I went to report, they told me they hadn't had my file yet.
Okay.
Come back.
Okay. And did you come back?
And when I went back, they said I hadn't got it in court yet. They
Yeah.
told me to come back on intake day.
Yeah.
And I ended up getting arrested.
Oh, before intake day could happen, you got scooped up for this?
Yeah.
Okay. Will you be staying on Amel Drive?
Yes.
That's still your good address?
Yes, sir.
What's the street number?
Amel.
Street number?
154 Amel Drive.
All right, I got a 568.
That's it, 568, yeah.
Okay. That sounds pretty different from what you were saying.
My bad, I'm sorry.
That's okay, but 568 is your spot?
Yes.
Okay.
Amel Drive.
Who stays there with you?
My mom,
Okay. All right. So Ms. Simpson, if I wanted to revoke 6 months, 180 days, given that Mr. Nolly has already done 160, should I just revoke 20 days and we don't even need to talk about credit for time served? I'm worried if I say 6 months, that's just long enough that then some hook will latch on to Mr. Nolly and he'll go.
Yeah, I was gonna say, you usually would included the credit in the revoke time.
Yeah.
So yeah, if you're gonna do the difference, it'll keep you here.
Okay. If I were to say I'm revoking 6 months, but giving you credit for the time you did, that 6 months would cause the system to say Mr. Nolly needs to go into the department.
6 months, him getting credit should keep you here.
Okay.
It should keep you here.
Got it. All right. So Mr. Nolly, what I'm going to do is give you credit for the 160 days you served, but I'm going to revoke 6 months of your probation, credit for the 160 days. You'll get out soon. The sheriff can give you 2 for 1 on the remaining 20 days if he wants to. You get out in 10 days or less. I'll reinstate your probation. And I'll just remind you, it goes without saying, a condition of your probation is you need to stay plugged in with probation. If they say, come to the office, you got to come to the office, and you need to be easy to find. If you've got 3 phones, they need all 3 of your phone numbers. They need your mom's number. If you got a girlfriend, they need your girlfriend's number so that they can call and someone's going to let you know probation is looking for you. Okay, if we're together again and it's another one of these, I didn't report, that's a minor violation, but it becomes more significant if you keep doing it. And we'll just have to turn up the temperature a little bit. It goes without saying, if we come together again and you have drugs in your car, that's going to be even more problematic. Here, you are having the outcome we're having because the police may have inadvertently cut a corner in the work they were doing. Next time, if they get it right, then we're not talking about months of revocation. And you got a long gangplank of probation, 9.5 years. So just be thoughtful about your hustle outside of the construction work you do, okay? Do you take care of your mom or she's just your roommate?
I'll take care of
And what does it mean to take care of her?
I'll be helping out with the bills, stuff like that.
All right, that's good. You should. You're her son. That's gonna be hard to do if I see you again in 6 months and have to revoke 3 years because you were doing some of this same stuff. So be thinking of mom, as you are doing what you do. Anything else, Ms. Davis from the state?
No, Your Honor.
Ms. Wood, on behalf of Mr. Nolly.
No, Your Honor, thank you.
Anything, Ms. Simpson, you need from me? Okay. And Mr. Nolly needs to report to probation when he'll be released in the next week-ish or so, maybe 2 weeks. All right, 48 hours, within 2 days of your release, you got to go to probation. You know where that office is?
Yes.
Where is it?
Downtown, across from pretrial.
Yes, exactly. And they're not going to call you or send you a note. You just need to know within 2 days of getting out. You go home, you hug your mom, and then you got to get to probation. Oh, you even have contact information for this poor, is it still Ms. Flemister? She'd love to meet you. Yeah, let's make it happen.
Yes, sir.
All right, thank you, everyone.
Thank you, Judge.
All right, so Ms. Jackson and Ms. Rivers, if you don't mind hopping back on at 1:30. If Ms. Nelson learns for sure that we are not able to take the plea with the Department of Corrections defendant, she can shoot you an email and you do not need to hop back on. But if you hear nothing, then that means we either haven't heard from this defense attorney and we're hoping for the best, or it is definitely lined up. And so I will hop on at 1:30, and if you would as well, we'll see. It's just one case left, and it's a plea with a guy in DOC custody. Okay?
All right, Judge.
Thank you.
the evidence in this particular case, Your Honor, allegedly was not married at the time. But we do not know what, if any, tests were done on that vehicle to confirm whether or not he actually did slam on his brakes. Additionally, the state makes the conclusion in their accident report that he could have been on the phone and the rate of speed, however, like I told Mr. Johnson, in the actual discovery, don't have the extractions from those actual instruments that take down that. So at this point, it's the officers or the accident specialist. We don't know where he got that from. But nevertheless, my client, he does suffer from anxiety and depression on that particular night at his brother's house in the middle of the night, because he was not feeling well that particular day. He had previously worked PA in Cobb County.
Hello, excuse me. Hello, hello.
Again, he has no history. When he found out that he had arthritis.
Karen, I think that's a different courtroom.
Oh, okay.
I don't see anyone in the courtroom.
Right. I was just like wondering where it came from. I'm looking at my computer saying, is my thing going? Okay. That was weird.
Interesting.
That's not the first time that has happened.
No, not at all.
How are you today?
I'm doing fine. How about you?
I'm okay.
It won't be a long one today, so we're almost done.
Oh, yeah. I'm just sitting here working.
Me too. I'm trying to eat a little lunch, but that's not working yet.
Oh, okay.
All right. Folks online should be able to hear us now. Mr. Hiles, can you hear us?
Yes.
Excellent. Let me take a couple things off here. So we will add you to the spotlight and we'll get Mr. Rhodes on. And there he is, Mr. Willis. Mr. Willis, can you hear us? You're on mute. Oh, now you're not. That was easy. Can you hear us?
Yes, sir, I can.
Excellent. Ms. Rivers, are you good to go?
Yes, I'm ready.
Okay. Well, thank you everyone for rejoining us, and thank you Department of Corrections for getting Mr. Willis to us on short notice. We thought we'd be able to connect with you yesterday, but I think some of your shops were down for the holiday. This is case 25 SC 002368, State versus Willis. Mr. Willis is appearing from the diagnostic facility at the Department of Corrections. His lawyer, Mr. Rhodes, is actually here in court with me. It's nice to have some company. And Mr. Hiles is appearing from his virtual location. And I think we're ready to go forward with a plea. Is that your understanding, Mr. Rhodes, of what we're doing?
Yes.
Okay. Mr. Willis, for us to get through the plea, Mr. Hiles will put you under oath. Once you're under oath, he's going to ask you questions about your rights as well as a few questions about the case. You'll need to answer those questions truthfully. And if you've got any questions of your own, you need to let me know. If there are things that you want to discuss privately with Mr. Rhodes, we can make that happen. I'll have him go into the jury room and put you guys into a breakout room so that you can speak confidentially. But if it's a basic question, you're welcome to ask me or Mr. Rhodes. But we need you to wave your hands or do something if you do have a question, okay?
Yes, sir.
All right. I will start before you get sworn in. Mr. Willis, you have a right to be here in open court. You also have a right to have Mr. Rhodes right next to you during these proceedings, but you can waive those rights and we can continue with you in the diagnostic facility and Mr. Rhodes here. Do you waive those two rights?
No, sir.
Well, by saying no, you're telling me you don't want to go forward and you want to be here in court.
I'm sorry. I do want to go forward. I'm sorry.
Okay, I didn't mean to ask it in a tricky way. You are okay proceeding virtually from where you are now?
Yes, sir.
Okay, and you're also okay proceeding with Mr. Rhodes here in court with me and not sitting right next to you?
Yes.
Okay, great. Then that's what we'll do. Mr. Hiles, when you're ready.
All right. Mr. Willis, will you please raise your right hand? Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Please state your true, correct, and legal name.
My name is Jamon Willis.
Okay. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
How old are you and how far have you gone in school?
I'm 45 years old and I graduated from Douglas High School.
Do you understand that in this indictment, you're charged with one count of possession of a firearm by a convicted felon?
Yes, sir.
Okay. Do you understand you have the right to plead guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, I understand.
All right. Did you go over the rights that you were waiving today with your attorney by entering a guilty plea?
Yes, sir.
Okay. Do you need any more time to discuss this case with your attorney, Mr. Rhodes?
No, sir, I don't.
Okay. Are you satisfied with Mr. Rhodes' services?
Yes, sir.
Okay. Mr. Rhodes, do you waive formal reading of this indictment?
For the purpose of this plea, yes, so waived.
Okay. And Mr. Rhodes, for purposes of this plea, do you waive any and all defects in the indictment, including any with respect to your client's name?
Yes.
Okay. Mr. Willis, do you have you been advised of the minimum and maximum sentence for each charge that you are pleading to?
Yes.
Okay. And do you understand that because this is your would be your second conviction for possession of a firearm by a convicted felon, this would carry a sentence of 5 to 10 years. Do you understand?
Yes, sir.
Okay. You understand that this is a negotiated plea of guilty, which means the state is recommending to the court a sentence of 10 years to serve 5 years with the balance on probation. However, the court does not have to accept the sentence and can sentence you up to the maximum on this charge. Do you understand?
Yes, sir, I do.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on entering a guilty plea today?
Yes, sir.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes, I understand.
All right. Mr. Willis, are you a United States citizen?
Yes, sir.
And do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or the Board of Pardons and Paroles, and no one can guarantee parole no matter what anyone has told you?
Yes, I understand.
All right. Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea, just as there would following a conviction at trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand?
Yes, sir.
Do you understand that by possessing a firearm in the future, you will be guilty of a felony?
Yes, sir, I understand.
All right. Do you understand that by pleading guilty, you're giving up the right to trial by jury?
Yes, sir.
Do you understand that by pleading guilty, you're giving up the right to remain silent and not incriminate yourself?
Yes, I understand.
Do you understand that you are giving up the right to confront witnesses called to testify against you?
Yes, sir.
And do you understand that you are giving up the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case?
Yes, I understand.
Do you understand that you are giving up the right to the presumption of innocence?
Yes, sir.
And do you understand that you're giving up the right to testify on your own behalf and present other evidence?
Yes, sir.
Do you understand that you are giving up the right to subpoena witnesses and compel the production of evidence?
Yes, sir. I understand.
Do you understand that you are giving up the right to have the charges against you proved beyond a reasonable doubt?
Yes, sir.
Do you understand that you're giving up the right to appeal if convicted of these charges after a trial?
Yes, sir. I understand.
Has anyone forced, threatened, or promised you anything to enter a guilty plea?
No, sir.
How do you plead to the charge of possession of a firearm by a convicted felon?
I plead guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, sir.
And do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, sir.
You understand you have 4 years from today's date to file a habeas corpus petition challenging the voluntariness and or constitutionality of this guilty plea. Do you understand?
Yes, sir.
Okay. And do you understand you have only until the end of this term of court to file a motion to withdraw this guilty plea? Do you understand?
Yes, sir.
All right. Your Honor, before I get into the factual summary of this case, I want to address a few of the issues. So he was a co-defendant with Malik Brown. Don't know exactly why in this circumstances they were put on the same indictment, but they were. Mr. Brown and Mr. Willis were stopped in February of 2024 and charged with similar cases, similar charges for Mr. Willis, the possession of a firearm by a convicted felon, possession of marijuana. He was not included on that indictment. For whatever reason, the person making the charging decision left that incident off of the indictment. Mr. Willis was then stopped again on January 19th of 2025, which is the basis of these charges. Okay,
That's what I see in the indictment is that for Mr. Brown, it all relates back to that February 22, 2024 traffic stop and consequences for him, which he's resolved. He's already entered a plea. For Mr. Willis, he's not, that date and incident isn't referenced. It's a strange indictment. It's glued together two defendants with different dates of offense conduct by almost a year.
So actually with Mr. Brown, the officer readily admitted, he's like, yeah, I saw Mr. Willis was driving. I saw the tire. It only hit the yellow line. It never crossed.
Oh, that's this case. Okay,
Yeah.
right.
The case law was clear. So those, even though they've been dropped, we're not going to bring them again as part of this plea. Additionally, as part of this plea, I don't know why there was some marijuana that was found in Mr. Willis's possession.
On the 19th of January of this year or February of 24?
On the 19th of January of this year.
Okay.
But by entering this plea, we're not bringing those charges back. I think it would set up a plea and bar anyways, but I want to put on the record that it was part of the agreement to not indict those charges since he accepted this plea.
Okay, well, that'll be in the record.
All right. So were this to go to trial, Your Honor, the facts would show that on January 19th of this year, Officer Cannell of the City of Atlanta Police Department was patrolling MLK Junior Drive when he noticed a Nissan Rogue with Alabama license plates cross the divider line, as well as the driver of that vehicle not wearing his seatbelt. The officer conducted a traffic stop. Mr. Willis was the sole occupant of the car. He initially noticed marijuana in Mr. Willis's lap, which was then turned over. And during the discussion, Mr. Willis informed the officer that he was in possession of a firearm inside the car as well. Mr. Willis was removed. The car was searched and the firearm was recovered. Mr. Willis was a convicted felon at this time. That would be the basis of our case should it go to trial. All acts occurring inside of Fulton County, City of Atlanta.
Okay. Mr. Brown is younger than... I'm asking about Mr. Brown, not Mr. Willis.
Yeah.
Mr. Brown is younger than Mr. Willis. Is that correct?
I believe so.
Oh, yeah, I have his date, 2004. I'm just curious, the pairing of Mr. Willis, who he is young relative to some of us on this call, but he's an old guy for being a gang guy. And Mr. Brown was not. Mr. Brown is 24 years younger than Mr. Willis, which means he was like 21 at the time. What is your understanding in talking with investigators of Mr. Willis's connection to Mr. Brown and PFK? He seems to have been one of these guys who would age out of some of that.
I don't think there is a connection at all. That's why there was no gang charge ever indicted for Mr. Willis. I think he was giving him a ride. I don't know what their connection is, but I don't think there's any connection to the gang, and that's why it was not charged.
Okay. And Mr. Willis, I'll ask you the same question. I was just curious what the state's theory was, and they didn't charge you with any gang stuff. It just was peculiar, now that I understand why your charge is connected to something from a year before. You and Mr. Brown were in the same place at the same time in February of 24. And you just don't fit the age profile of Mr. Brown and the guys he is known to consort with. And I was curious. What else did you want to add, Mr. Hiles, if anything?
That's all.
Did you have conditions of probation?
I mean, just did he not violate any future, no future violations of the law?
All right, well, that's baked in. Just wondering if there was anything like stay away from Malik Brown or anything like that.
I didn't make that a condition or anything of that.
Okay. I'm not rocking the boat. I just wasn't sure. You often, because it's required in gang cases, you've got a bunch of things, but this is not a gang case. And so it was, you just had the 10 serve 5. Okay.
Yeah, after all, I mean, I kind of went down the investigative path as to why they would bring gang charges for both, since neither one was in a gang. And I determined that Mr. Willis had no connection to the gang, so I didn't put any of those conditions.
Okay, got it. Oh, you determined that Mr. Brown also was not part of Play for Keeps?
No, I think he is 100%. They were, I mean, just because he had a weapon, I was trying to get them to explain a nexus to me, and they couldn't, other than he was in a gang. And so I was sitting there like, why are we going down this road?
Okay, it's not that Mr. Brown was not a gang member. It's that particular incident in February of 24, it may have involved criminal conduct on his part, but not gang related.
That's exactly when you have two people in a car that one is a gang member, one's not. Huge age gap. Thought about all that. So
okay, got it. Let me hear, please, from Ms. Jackson about any criminal history for Mr. Willis.
Is this, you said Mr. Lewis or Mr. Willis?
Willis. Mr. Willis is position 6 on the add-on calendar.
Okay, there are 20 cycles. The last arrest was January the 19th, 2025, with the City of Atlanta Police Department for possession of marijuana with the intent to distribute, and possession of a firearm during commission of a felony, and possession of a firearm by a convicted felon. He does appear to be on probation. That case number is 23 SC 189454 for aggravated assault and possession of a firearm by a convicted felon. That disposition date, was March the 13th, 2024, and the term is 4 years and 8 months. He does have prior felony convictions, one in 2011 out of Rockdale County for 2 counts of forgery in the first degree, and battery of family violence, a felony. And he received first offender treatment in 2008 out of DeKalb County for false imprisonment. That case was sealed July the 6th, 2017. And there was one in 2002 for cruelty to children in the first degree. Nothing in addition, Your Honor.
Thank you, ma'am. Ms. Simpson, good afternoon.
Afternoon, Judge.
Is Mr. Willis is still on probation for that 23 SC case. Has this incident, the having a gun in January of this year, popped up on probation's radar, or do we have a potential?
Yes, Judge. He had a revocation in June of this year before Judge Ingram. So that is what he's actually serving on in custody, I believe.
Got it. Okay.
Yeah, she revoked the balance, so that's what he's serving.
Okay.
He does not have any probation to follow.
Okay. Understood. And the revocation was predicated on these charges.
Yes, Judge.
Okay. Makes sense. Mr. Rhodes.
Yes, sir. Oh.
No, soon. You're almost. I go to you last, Mr. Willis. You get the last word. It's good. That's all right.
Yes, Judge, everything you've heard is correct. Of course, Mr. Willis is not affiliated with any gang. There's no contest there. And yes, he is serving currently on 23 SC 189-454 on a probation rotation balance, the balance revoked. We would just ask that the sentence imposed run concurrent with that rotation. And yeah, we would leave it to the court at that, but yeah, we would ask the court accept the pleas negotiated.
Okay. All right. Mr. Willis, anything you want to add? I was asking Mr. Hiles a bunch of questions about your case, and it's yours, not his. So I'm happy for you to share anything, or if you've got any questions for me, I'm happy to try to answer them.
No, sir. No, sir, y'all. I don't have any questions.
Okay. Mr. Willis, are you when you are eventually released, will you be coming back to Atlanta? Where will home be?
Yes, it'll be at yes, it'll be in Atlanta, it'll be in Fulton County.
Okay. And how was it that you ended up being in the same car with Mr. Brown back in February of 24?
Mr. Brown is my my little cousin, and I was taking him home. That's what I was doing, y'all.
Okay, so you know him through family.
Yes, sir. My mom and his mom is first cousin.
Got it. Okay. Thank you for explaining that. Well, Mr. Willis, I find there's a factual basis for your plea. Your case is pretty simple. You were driving a car and there was a gun in it, and and you were the only person in the car, so the gun is attributed to you, and you know very well you're not supposed to have a gun, and you're going to need to figure out a way to get that out of your system. I also find that your plea is knowing and voluntary, so I will accept it. I will also follow the joint recommendation, which is a sentence of 10 years to serve 5 years with the balance probated. You will get credit for the time that you've been in custody since January 19th of 2025. And I will run this sentence concurrently with your revocation in 23 SC 189-454. No special conditions of your probation. Just know that a condition of every probated sentence is that you obey the law, which means if we fast forward a few years and you're out and you get pulled over again and there are drugs or there is a gun or there are both in your car, then we're just going to repeat this process, and then you're going to be 50 years old and then 55. And I hope you're ready to try to turn a corner away from that so that you can be around friends and family and do other things than be a guest at the Department of Corrections. Do you need to provide Mr. Willis with any reporting instructions, Ms. Simpson?
Not really, Judge. But I will, just for the record, he will need to report within 48 hours of his release. But the facility where he is at will give him further instructions in regards to that.
Got it. Okay. Mr. Hiles, anything else from the state?
That's it.
Mr. Rhodes, anything on behalf of Mr. Willis?
Nothing else.
All right. Mr. Willis, anything else?
No, sir. No, sir.
All right. Well, good luck with everything. And thank you, Ms. Hemmings, for making Mr. Willis available for us. Ms. Jackson, Ms. Simpson, Ms. Rivers, everyone, have a good rest of your day.
Thank you. You as well, Your Honor.
All right. Bye-bye.
All right, thank you, Judge.